Having a domestic violence protective order against you changes everything. Where you can live, who you can see, even if you can see your kids. And if you don't challenge it fast, the order can stick around long after the case is over. I'm Nana Knight, a criminal defense attorney here in California, and I help people remove protective orders that should have never been granted in the first place. This video walks you through the exact process to challenge a domestic violence order, what the court actually looks for, what evidence matters, and how to give yourself the best shot at getting it lifted. Because if you handle it right, you don't have to live under these restrictions forever. So who can ask to remove the order? A domestic violence restraining order usually has two roles. There is the protected person, the person that the order is meant to protect, and there's the restrained person, the person who is ordered to stay away from the protected person. In most cases, the restrained person is the one who wants it lifted, but the protected person can also ask the court to change or end it. And here's what you cannot do. If you are a friend, a parent, a sibling, someone trying to help, you usually cannot walk in and file to remove it on your own. It typically has to come from one of the two main parties. Now, does it help if both sides agree? Yes, it helps a lot. Is it guaranteed? No. Judges are still going to treat those orders like safety orders, not relationship paperwork, even if both people show up smiling. So the first fork in the road is simple. What kind of order are we talking about? Because the process changes depending on the type, and timing matters because not all orders are the same. In California, you will usually see one of the three stages. An emergency protective order that is usually requested by law enforcement who is on the scene responding to a domestic violence call, and it is very short, up to 7 calendar days. A temporary restraining order. That is the short-term order that lasts until the court hearing. And then the long-term order after hearing, what people call as a permanent restraining order. Even though it is not forever, it is commonly issued for up to 5 years, anywhere between 1, 2, 3, up to 5 years. And here's the important part. A lot of people focus on the removal too late. If you're dealing with an emergency order, it may expire before you can even get in front of a judge. So if you are dealing with a temporary order, the real right is usually the hearing, because that is where the court decides whether to extend it into a longer order. And if you already have the restraining order after the hearing, that is when people usually file a request to change it or end it early. So before you do anything, look at your paperwork and confirm what you have, because filing the wrong request wastes time, and time is one of the things you do not have when an order is affecting your kid, your home, or your job. Now let's talk about the practical process. What you actually do. The practical process to ask the court to end it. I'm going to keep this simple. There are 3 big steps. Step 1, file the request. Step 2, serve it correctly on the other party. Step 3, show up and prove the change. If you have a civil restraining order after a hearing under the domestic violence process, California courts use a form called DV-300, request to change or end the restraining order. And there is an information sheet too that comes with it that you can also find online. It's called the DV-300 info form that explains the process and what it's for. Now, quick warning, because this is where people mess up. That DV-300 process is generally tied to changing or ending orders made after the hearing. If you're still in a temporary stage, you usually handle changes at the hearing itself or through the court's guidance, not by guessing and filling out random paperwork. So if you are in the temporary stage and you are not sure what to do or what to file, do not freestyle it. Call the court self-help center in your county and use their resources. Now, what do you put in that request? This is where people get too vague. You cannot just say, we're good now, and expect the judge to sign off. You need to explain what changed. Not in a dramatic way, in a clean adult way. Things judges tend to care about. Things like time has passed without any new incidents, or proof of counseling or programs that you completed, compliance with the order, stable living arrangements, and whether the protected person actually feels safe and is acting voluntarily. And yes, if both sides agree, you should make that clear. But remember, judges will still pressure test it to make sure nobody is being pushed. Now let's talk about the step that trips people up even when the paperwork is perfect. Service. Service and the hearing, where most people lose. After you file, the other side has to be properly notified. You usually cannot be the one to serve the papers yourself. If you skip service or do it wrong, a judge can deny your request without even getting to the substance of your request. Then you get your hearing date. And at the hearing, the judge is trying to answer one question. Is it safe to change this order? Not, are they a good person? Not, do they love each other? Safe. So if you show up and your entire argument is, I promise it won't happen again, that is weak. If you show up with specifics, proof of compliance, proof of change, and a calm explanation, that's stronger. If kids are involved, expect extra caution because courts treat child safety as its own category. And here is another thing people do not see coming. Even when a domestic violence restraining order expires, some custody, visitation, or support orders can keep living on unless the judge changes them. So if part of what you want is to change the custody or visitation terms, you need to talk to a family law attorney about that piece and get advice on how that works in your county. Now, we need to address the other big fork in the road because not every protective order is a family court domestic violence restraining order. Some are criminal protective orders, and those are a different animal. If it's a criminal protective order, it's different. If it's a protective order that was issued by a criminal case by a judge who's presiding over a criminal matter, that is typically a criminal protective order that's issued either during your arrest or after the case has already been filed against you. And these are common in domestic violence prosecutions, and judges often issue them early in a criminal process, usually at the arraignment stage. And here's the key point. Even if the protected person wants contact, that doesn't automatically change the judge's order. The order belongs to the court. So a request to modify a criminal protective order usually has to be addressed in criminal court, and the process often involves the attorneys that are involved in the case. In Santa Clara County, the judges want to hear from the protective party or the alleged victim in the case before they change anything in the order. That is why you will hear people say you need to go through the DA, or you need to talk to the defense attorney, or you need to calendar the case in front of a judge. The exact steps vary by county, but the takeaway is the same. Do not assume the family court domestic violence restraining order process applies in a criminal case. Now, let's answer the question people are afraid to ask. What if the judge says no? What happens if the judge denies your request? If the judge says no, the order stays in place. That does not mean you are doomed forever. It usually means the judge is not convinced the risk is gone yet, or the request was not supported the way it needed to be. In Santa Clara County, for example, the victim may need to complete a safety planning class before the order is changed in court. So in some situations, you can try again later if the circumstances change materially. But here's what you do not do. You do not treat a no like, well, we tried, so now we can do what we want, which brings me back to the open loop from the beginning. The biggest mistake that get people arrested, even when both sides want the order gone. The biggest mistake, and here it is. They start communicating again because it feels mutual. They meet up, they text, they call, they go on a date, they hang out just for a minute because they feel like it's mutual, or the other party, the protected party, reached out first. Sometimes the protective person invites it, right? And they tell themselves it's because we both agreed, but the order is not a suggestion. If it says no contact, it means no contact until the judge changes it or lifts it. So violating a protective order can be a new criminal case all by itself. In California, it could be grounds for a new misdemeanor charge against you. And it can also destroy your credibility when you go back to court asking for the order to be lifted. So the smartest way to get it removed is boring, but it's more effective. Follow it perfectly, file the request the right way, serve it correctly if it's a domestic violence restraining order in civil court, show the judge real change, and that is how you win this. So let's do a quick recap. If you want to remove a domestic violence protective order in California, first identify what type of order you have. Is it a civil domestic violence restraining order? Is it an emergency, temporary order after a hearing? Or is it a criminal protective order? Second, use the correct process. For a civil domestic violence restraining order, after a hearing, the courts commonly use a domestic violence form 300 to request a change or end it early. Third, do not skip the personal service and do not wing the hearing. Bring proof and be calm, and present your case well in court in front of the judge. Fourth, if it is a criminal protective order, treat it differently and address it in criminal court through the criminal justice process. And the big one, do not violate the order while you are trying to remove it. Now, if this helped, you should watch my next video over here, how to beat a domestic violence case in California, because a protective order is one piece of that problem. The criminal case is the other. Now click that video now, and I'll see you over there.